With thanks to Berkeley Law Center for Law and Business and Delia Volante, the Center's Associate Director, for inviting us to contribute. And special thanks to my co-panelists, Dr. Emily Beeny and Dr. Robert Mintz, for joining me today to talk about provenance. I view this topic through a legal, curatorial, and historical lenses in my roles as attorney, instructor, curator, and researcher. And I want to begin the discussion, let me put this slide up, with the question of why does provenance of art and other cultural property matter? And actually, the talk on AI made me, they use provenance in a very different way, but not so different, and certainly worth circling back to at some point. So I'm going to cover some of the legal overview, and then we'll move into some other discussion. So from a legal perspective, the provenance of a cultural object, its history of ownership and possession, can provide evidence of good title or ownership, or the lack of it. Disputes over the ownership of cultural objects arise in different contexts, and these together have a synergy that drives the evolving topic of provenance, due diligence, and standards of care. So these contexts include Nazi-era confiscations, antiquities looting, illegal exportation from source nations in violation of their national heritage laws, illegal importation, indigenous claims, and now most recently suspect acquisitions during the colonial era. So under US law, a thief cannot pass good title to stolen art, not even to a good faith purchaser for value, although there are defenses that may be asserted. And in addition to civil disputes between private parties, sometimes involving foreign nations and their museums and other institutions, in appropriate cases, customs and federal and state criminal laws may be applicable. Therefore, understanding the provenance of cultural objects is essential, both as a sword and a shield in ownership disputes. These disputes can result in liability for buyers, sellers, intermediaries, museums, collectors, and others, as well as reputational harm. So provenance evidence can also inform authenticity through confirmation of the chain of custody and ownership. And in addition, one of the first questions one must answer in evaluating provenance is whether the object is authentically what it purports to be. And is it an authentic match for the allegedly stolen object? Provenance is relevant to value of a cultural object. If it was owned by a celebrity, it could be worth more, but if it has a tainted or suspect provenance, it could be unsellable, might be driven underground, might go to jurisdictions where a theft victim is not protected. When ownership disputes arise, normally we've applied laws traditionally, but we have new developments in this area where an ethical returns policy was implemented by the Smithsonian just in May of 2022, and similarly in October of 2022, the Association of Art Museum Directors published guidance on art from colonialized areas. So we're kind of going beyond the law with some of these claims. And then provenance is a potent tool for the curatorial narrative in education by providing a multi-layered lens through which to understand the object, the people tethered to it, and related historical, political, cultural, and other meanings. I want to mention dealers and auction houses, of course, as most of you know, are the main conduits through which artworks are transferred in the secondary market. It is a trade practice to maintain provenance in confidence for many decades on the basis of privacy. So when there is a theft in the history of an object, this trade practice can obscure historical transactions for long periods of time. Therefore, there can be a tension between privacy rights, trade practices, and the need for transparency to conduct provenance, or to conduct research and have access to this information. So I wanted to just go through a few of the legal issues that we tend to come up in this area, in cultural property ownership disputes, where provenance plays a role. So as mentioned, claims are litigated in civil proceedings, just one private party against another. But this field has really generated a lot of legal proceedings involving state and federal criminal laws and federal customs laws, so involving the Department of Justice. So the Department of Homeland Security and the FBI are frequently involved in investigations in this area. And as I mentioned, the Department of Justice very frequently seeks recovery of stolen or illegally exported cultural objects, law enforcement proceedings, and actually the local DA in Manhattan is very active as well, so this can take place on a more local level. Law enforcement proceedings can be particularly threatening to good faith acquirers because they often involve a warrant for seizure of the cultural objects and forfeiture proceedings. There are defenses that can be raised, and the National Stolen Property Act, a criminal statute, prohibits the knowing transfer of stolen goods in interstate or foreign commerce that are valued at $5,000 or more, as well as a knowing receipt, sale, storage, or possession of these goods. So this and other federal criminal laws under Title 18 can provide a basis for prosecution. And things like smuggling and false statements, material statements on customs forms. And you have to remember, these things travel in the stream of commerce, so although there may be events like this, innocent good faith purchaser could be the downstream acquirer. US customs laws are a frequent basis for these kinds of disputes. The 1970 UNESCO Convention comes up quite a bit, and we didn't implement this until 1983 in the United States, so that's actually our legal trigger date. But this can be the basis for qualifying stolen and illegally exported cultural objects. It's important to understand foreign national cultural heritage laws if they're true ownership laws, which are often very relevant in the analyses. And for Native American cultural items, we have the Native American Graves Protection and Repatriation Act and a very new statute called Safeguarding Tribal Objects of Patrimony, the Patrimony Act, which was passed in 2021. We have new anti-money laundering legislation. It was passed under the National Defense Authorization Act of 2021, which includes provisions that expand the scope of the U.S. Bank Secrecy Act to include, as financial institutions, people engaged in the trade of antiquities. So this includes advisors, consultants, or any other person who engages as a business in the solicitation or the sale of antiquities. Rulemaking is still in process through the Department of Treasury's Financial Crimes Enforcement Network, but this legislation will exact new legal responsibilities regarding, among other things, customer and provenance due diligence. We also have non-binding international principles that many nations have agreed to. And I have a couple of examples up on the slide, the 1990 Washington Conference Principles and the 2009 Terrorism Declaration, which has really impacted pretty dramatically conduct by nations trying to solve these claims. So the museum community has established its own voluntary standards and guidelines regarding provenance due diligence. The heavy burden of this difficult and complicated research often falls on our museums and other collecting institutions and their expert staffs. So Dr. Beeny and Dr. Mintz, your museum collections are very different in nature and scope. Emily, you oversee European paintings at the Fine Arts Museums of San Francisco, and Dr. Mintz, cultural objects of all the major Asian nations spanning 6,000 years in every region of Asia are at the San Francisco Art Museum. Can you give us an overview of the provenance due diligence practice at your museums and how it's evolved recently? Because it's a evolving field with a lot of developments.
Well, thank you so much, Carla, and I want to thank you and Delia for convening us, and obviously it's a treat to be with all of you here at SF MoMA. In terms of our work in the Department of European Paintings at the Fine Arts Museums of San Francisco, we have rigorous processes in place for acquisitions. So we strive to compile thorough documentation, of course, on each picture that comes into the collection. And in cases of works that are undocumented between the years of 1933 and 1945, those works are run through a battery of different checks. including the databases of the ERR, Jeu de Paume, the Munich Central Collecting Point, various tools available through the Getty Provenance Index, and then a number of state-sponsored digitized photo archives related to works that changed hands during this period. We also often work with the Art Loss Register, which is a major organization that helps many institutions with research of this kind. We're also, bit by bit, working through the existing permanent collection of European paintings to better document and understand the ownership histories of paintings in the collection. Of course, this is a collection amassed through gift and purchase over the course of many decades, starting in the late 19th century with the founding of the De Young Museum, and so it's a task that takes time, but I think, I really see the imperatives as twofold. There is, of course, the legal and moral obligation to honor the Washington Conference principles and be sure that we do not hold in the collection objects to which we don't have good title. And then there's also the scholarly dimension of this, the scholarly imperative, I think, to better understand the stories of the paintings in our care.
That's great. So I won't repeat most of those things because we at the Asian Art Museum similarly look to those public registers. I do want to say, in Europe, there is a healthy effort afoot to make sure that documentation, particularly of Nazi-era provenance, is clearly present. For Asian objects, things coming out of Southeast Asia, East Asia, South Asia, and West Asia, there are widely varying practices in place and very few databases of past actions and unfortunately there's a history of conflict that's very dramatic, particularly in South and Central Asia, Southeast and Central Asia. What we do is, again, for incoming new works to the collection of the Asian Art Museum, we are very rigorous in searching all of the possible sources we have and really questioning the source donor or the source dealer, and demanding that we see a clear path from the source country to ownership and then, of course, to gifting to the museum or purchased by the museum. That means we very rarely welcome in antiquities into the Asian Art Museum. We collect primarily contemporary art at this point. On the issue of searching the past collection, we do our best. We're limited by human resources, financial resources, and most of all time to go through each object. What we look for very specifically are objects that were entered into the collection after, for example, the date of the UNESCO treaty's language being discussed. So we use 1970 to say, if it was acquired after 1970, we must look more closely. And then we seek the import documentation, ideally the export documentation from the source country, and then we feel confident. We rarely feel confident today, so.
Thank you. So the 1970 date has been adopted voluntarily by the museum community, but actually the laws use 1983. So it's kind of an interesting situation. And you actually addressed it, but I think it's really important to point out, if you're acquiring new things, it's one thing to engage in provenance due diligence today, but when you have a collection that goes back,
50 to 100 years?
Yes, and to do retrospective provenance due diligence research, I don't know whether either of you want to just, it can be very, very daunting, I'm sure.
It's always a matter of finding the things that seem to have a red flag attached. That's where we start. The things that we know nothing about, they may sit on the shelf unresearched for my lifetime.
Right, right. Well, now each of you have brought a case study to share with the audience, and so Emily, do you want to start, and then Rob can finish off?
I thought I'd provide sort of a fun case study, although obviously a case study with some very dark dimensions as well. As we've been discussing, I look after the European paintings collection, and this is really a corner of the field in which issues of ownership and sale and expropriation from Jewish collectors in the years between 1933 and 1945 really present the most burning provenance questions. I recently heard a market-based provenance researcher describe this period as the Big Bang in European art, a moment obviously of tremendously violent political and economic upheaval when millions of objects change hands. So there are, of course, legal transfers of ownership that take place during this period, but the scale of looting, the scale of Aryanization of cultural assets, the scale of forced sales in this period really kind of beggars imagining. And I think that it will, tracing the trajectory of individual objects through this period will continue to occupy researchers probably for generations to come. It's in the immediate post-war period, in the sort of initial attempts to put Humpty Dumpty back together, to try to reverse the Big Bang, that modern provenance research is really born as a field. And so the case study that I'll share today actually dates from that moment. But for me, as a specialist in early modern European paintings, it's a story that starts much earlier, of course, in the 18th century. This is a series of pictures painted in 1752 to 53 by the French artist Carl van Loo. And as you can see, it's a series of allegories of four arts. So from left to right, painting, sculpture, architecture, and music, imagined as babies. So we obviously have the painter and model at left, a little sort of toddler sculptor chiseling away at a portrait bust of Louis XV, a wee architect presenting the elevation of a chateau, and then finally music, where the little musicians gather around a harpsichord with an actual legible partition of a piece of music on it. I think these pictures achieve an inadvertently surreal effect for us today, and they're certainly always a favorite in public tours of the permanent collections at the Legion of Honor. One of them, actually, architecture, was also featured in Alfred Hitchcock's classic film Vertigo. But they were originally painted for the Château de Bellevue, which is actually the chateau presented in the elevation in the architecture allegory. It was the private residence of Madame de Pompadour, the mistress to Louis XV. And let's show her here in a portrait by Boucher. And as you can see, these paintings, as recorded in the print on this slide, originally had sort of scalloped edges. They were designed to fit into curved boiserie wood moldings in the walls of a room at this chateau. It's probably in the late 18th century that the corners are squared when these paintings get transformed from permanent architectural decorations into portable property, into framed gallery pictures as they begin their long, strange journey of migration to San Francisco. They're recorded in the inventories of the Pompadour and of her brother, the Marquis de Marigny. They pass through a number of public sales in Paris and London in the late 18th century and throughout the 19th century. And then they resurface in Vienna in the collection of the banking family Rothschild. So by the time of the Anschluss in 1938, their owner is Alphonse Meyer de Rothschild, or von Rothschild, known in the family as Buster, a mild-mannered stamp collector, philanthropist, and hero of the First World War, who married an English woman called Clarice, and the couple divided their time between London and Vienna. Fortunately for them, they are in London at the time of the annexation of Austria. They managed to meet up with their daughters in Switzerland and ultimately to emigrate to the United States, where Buster dies 4 years later. But in the meantime, the Nazis have inventoried the family collection in Vienna, and it is a page from that inventory that we see on this slide with a detail showing the entry for the 4 Van Loo allegories. You'll see that they're accompanied by a stamp designating them for the planned Führer Museum at Linz, a project that was thankfully never realized. As I'm sure many of you know, in the final years of the war, Nazis stashed huge sort of hordes of looted artworks in salt mines, sprinkled throughout Central and Eastern Europe, far below the surface of the earth, safe from bombardment and, ironically, from further looting. And the Van Loos ended up in one such cache at a salt mine called Alt-Aussee, not far from Salzburg. It's a cache that's discovered and cataloged by the elite Allied corps of art experts known as the Monuments Men in 1945. And in this slide, you see a few of the Monuments Men actually in that mine, sifting through the paintings. Recovered works from sites like this one were gathered together in a network of warehouses in Munich known as the Central Collecting Point, where they were cataloged and numbered. And so here what we see is the cataloging card for the allegory of architecture, with a photograph on one side and the cataloging information on the other. You'll notice that under sort of possessor/depot, which is on sort of the far left of the card, the cataloger listed simply Hitler. And then under the cataloging number, which appears at upper right, matches the one inscribed in blue on the back of the stretcher of our painting. And here I would just say that the backs of paintings present an extraordinary resource for provenance research. This is often where you can find hand-inscribed numbers corresponding to inventories, corresponding to lots within auctions, public auctions. Sometimes you can find stickers applied by dealers or collectors or museums that have borrowed works over the years. These traces can really be an invaluable tool as we attempt to reconstruct the ownership history of a painting. So the 4 allegories are restituted after the war to Buster's widow, Clarice, who sells them through the New York dealer Rosenberg and Stiebel to the Legion of Honor in 1950. The director who was responsible for this purchase was a man called Thomas Carr Howe. He was a graduate of Paul Sacks's famous museums course at Harvard, who suspended his directorial career from 1945 to 1946 in order to serve as a monuments man. He was on the team that discovered and cataloged the cache at Alt-Aussee, and so he really understood the story that these paintings would bring with them to San Francisco. And I really like to believe that the legacy of Thomas Carr Howe animates the ongoing provenance research that we do at the Fine Arts Museums, and especially the kind of dual imperative behind this research, to make sure we are not holding in the collection objects that do not belong to us, but also to really fully understand the stories of paintings like this one, the strange, sometimes arduous journeys that they've gone through, over centuries and seas, and the kind of miracle of survival of these bits of canvas and wood. Yeah.
Thank you very, very much. So Rob, how about
Great.
very interesting case study?
That was like the good cop side, and now I feel bad. So I want to tell you about something a little bit different. So in 2020, we all had the pandemic. We had time to do provenance research. We had time to look at some of the things in the Asian Art Museum's collection that have red flags. And one of the things that had a red flag was this work. You can see its accession number there, the last little bit of information, B87S3. That means it was entered into the museum's collection in 1987. And we know that it is what it says up there, an architectural panel. It came from Afghanistan, from the Royal Palace of Masood III. So a wonderful thing. But 1987, if you think about it, 1987 is an important time for Afghanistan. That's the time of the Soviet occupation. The Soviets would be there until 1989. It was a time of civil war. It was a time of distress in the country. The question became, how long has this piece been outside Afghanistan? Or was it the byproduct of conflict? It turns out it comes from a very well-known site, which in 1958 was archaeologically excavated and documented by an Italian team, the Italian team working with the then Afghan government. documented every piece at the site, including our panel, which here is the photograph of our panel in 1958, not at the palace, but rather repurposed, reused on the top of what's called a cenotaph, a part of a tomb, very close to the palace site. Essentially, it was harvested, dug up, used as decoration, and served as the surface, the paving stone on top of this burial site. That means in 1958, it was comfortably at home in Afghanistan, and sometime between 1958 and 1987, it made its way to San Francisco. So we started our process of thinking about what this means by asking, when were the laws, the patrimony laws, the cultural property laws, and export controls voted in place in Afghanistan? And it turns out that year, 1958, was the year in which new laws were drafted in Afghanistan, and in 1959, late 59, they were voted into force. We suspect our panel was still happily residing in Afghanistan, possibly, prior to the imposition of this law. So the next step was to do provenance research looking for documentation. It could have legally left Afghanistan, and it should have documentation that would have gone with it. Unfortunately, there's no documentation we could find filed anywhere. And of course, you know the Afghan government has changed multiple times since that period. So there was very little paper trail. The next thing we looked for was an import document. We don't know how it got to New York City, where an American dealer served as the conduit, essentially selling it to private donors who donated it in commemoration of our founder's birthday. So it came to us through what appeared to be legal purchase through New York City, but with no paper trail preceding its arrival in the United States. All of these were additional red flags surrounding this particular work. So the staff of the museum decided it would be in our best interest to recommend to our commission. The commissioners oversee the public collection owned by the city and county of San Francisco. We recommended to them that the piece be deaccessioned, removed from ownership, removed from the official ownership of the city's umbrella, essentially come off the rolls of the city's collection. That vote went into place in 2021. We require that 6 months pass and that the resolution or the recommendation for that vote be presented a second time to make sure that we're confident that it is the right recommendation. And again, that was passed. And officially, we deaccessioned this piece, stating that we would then investigate potential repatriation or potential discussions of transfer of ownership to the government of Afghanistan. During the process of those votes, the government of Afghanistan dissolved, the American military pulled out of Afghanistan, and the Taliban returned to power, and the consular network, as well as the embassy of Afghanistan, ceased to be. And so the piece remains on the wall of the museum. It now states that repatriation is pending, and we declare that the ownership we should recognize, as far as we understand, should be with the Afghan people. Yet, we don't know that the object illegally left Afghanistan. We don't know that it was illegally imported into the United States. All we know is we feel ethically that the responsible act is to say the Afghan people should be in discussion about the future of this object. The challenge now is the path of communication to the Afghan people, which stopped at the time of transition of government. So the piece is here.
I think an important part of the end of that is that you've placed online where the world can see the status of this work.
Yes.
So the world is on notice that.
Yeah, if any of you know friends in Afghanistan, please reach out to me and we'll talk about the future of this object. Right now we treat it as a teaching tool, essentially to say this is a path forward for understanding objects for which we have very little documentation.
Which is, in terms of how common that is or not common, going back very far. I mean, since provenance really wasn't a focus, there wasn't the same sense of collecting this sort of documentation. So this is a problem in the area. Yeah.
Great.
Okay. Okay, thank you very, very much.